Disclaimer. Judge Ron Rangel is providing this podcast and website for educational purposes only, as well as to give the public general information regarding topics related to the criminal justice system. The views, thoughts, and opinions of his guest speakers are the speaker's own and do not represent the views, thoughts, and opinions of Judge Rangel. All rise. You are now listening to Beyond the Gavel with Judge Ron Rangel, educating the public and expanding mindsets. Subscribe on our website, beyondthegavelpodcast.com, or your favorite podcast platform for more of the latest podcast episodes and updates.
Welcome to Beyond the Gavel with Judge Ron Rangel. I'm your host. Today in the studio we have Benton Leachman. Now, Benton Leachman is a felony prosecutor in Bexar County, Texas. He grew up in El Paso and is an alumni of Texas Tech for both law school and his undergraduate educations. He's a singer-songwriter who's performed across the state of Texas and has had his work featured on Netflix. He's been with the Bexar County DA's office since 2017 and is currently the senior prosecutor assigned to the Protective Orders Division and handles high-risk protective orders. Welcome, Benton.
Thank you very much for having me, Judge.
Hey, I appreciate you coming in.
Yes, sir. Anytime.
We're going to touch on protective orders today.
Sounds great.
Before we get into that, let's get a little more information about you. You like being in San Antonio?
I sure do, Judge.
What is it you like about it?
Well, other than the people and the great food and the great city, I really like practicing law here. I do think our legal community is something special, and there's great collegiality between everybody on the bench and in the bar, both prosecution and defense, and I think that's a really special thing.
It's a good climate, right?
Yes, sir.
Yeah, people genuinely respect each other here. Well, we get a lot of communications here in the court related to protective orders. When I first started at the DA's office in the mid-90s in Hidalgo County in Edinburgh, I was first hired on to work in an area that was called the Civil Division. The Civil Division handled juvenile cases, it handled protective orders, and CPS cases. When I think of protective orders, I think about high-stress situations. People are coming in looking for some sort of relief or help from the system. What exactly is a protective order?
So, plainly speaking, is a judge's or a court's order that is prohibiting a person from doing a list of things. Mm-hmm. There's different types of protective orders that exist, but generally all of those share in common that it is a court's order, that it lists certain prohibitions, and that violations of those provisions may result in arrest.
So when somebody first comes in, let's say somebody has a situation where they want help, the district attorney's offices in Texas, generally speaking, are involved with that process, right?
That's correct.
Somebody says, I'm afraid of family violence in the home, I need a protective order. They could either hire a lawyer.
Yes.
Or they could go to the DA's office and say, I need a protective order. Who do I talk to?
That's correct, Judge. The state has been nice enough to give us the authority to go into civil court and request civil orders for this particular issue.
So what happens then? What happens when somebody comes in and says, I need some help? What's the process like in Bexar County?
In Bexar County, we start with a central intake process at the Family Justice Center. That central intake process, because the Family Justice Center is not just the DA's office, we're just one part that's associated with the nonprofit that is a collaboration of agencies that all make up the Family Justice Center. So when it goes to central intake, the first thing that's done is there's an assessment to figure out what services are needed, and also to attempt to figure out if there's any conflicts that the DA's office might have if a protective order is part of the services that they're seeking. In the event that there is a potential conflict there, the referral for the protective order services may go to Texas Rio Grande Legal Aid, who's another one of our nonprofit partners. If it is a DA's office eligible case, it's then referred to a victim advocate to start conducting a victim interview, and that can be done either in person or over the phone.
I'm on the executive board of the Texas Rio Grande Legal Aid, so I'm familiar with how that organization handles protective orders and protective order applications. You mentioned that the Family Justice Center is a nonprofit with a lot of agencies that are involved with it.
That's correct, Judge.
How exactly is a Family Justice Center funded? How is it that they came about? What's the concept with that?
The funding is in part from government agencies, along with fundraising events. I know that we've got the Family Justices Golf Tournament coming up here shortly. That's another way that we end up doing fundraisers. We have a gala fundraiser that I was lucky enough to be able to attend this year, but the DA's office is a partner to the nonprofit, but it's not just the DA's office. There's a lot that goes into it beyond just us.
So then the Family Justice Center here in Bexar County is located not in the courthouse, but across the street from the courthouse.
That's right.
What's the address so folks know?
That's 126 East Nueva, and we're the second floor.
And that's a beautiful building. That's the old archives building at Bexar County.
Yes, sir, and the Federal Reserve before that.
Oh, wow. So there's a little history in there. When you go in there, do you feel like all of a sudden you got money that's just waiting for you? Is that the deal?
There are some old bank vaults up there on some of the other floors, and they're pretty spooky, honestly. They're kind of scary.
Yeah. You know, you talk about somebody goes in there, they make an application. There's some things that you do at the onset. One of the things that you mentioned is conflicts. What type of conflicts would keep you from being able to help somebody who's asking for a protective order?
The primary reason the DA's office may have a conflict when it comes to a protective order application is if the person who is seeking the services is awaiting charges. The DA's office does not want to be in a position where we're going to be representing somebody effectively, although the state of Texas doesn't represent people on protective orders. It is adjacent to representation, and we don't want to be in a position where we're putting them in the position where they may negatively affect their penal interests.
Somebody comes in, they're talking about a protective order situation. They're giving you personal information.
That's right.
You know, they're talking about their histories or telling you how they feel about things or giving you stuff that theoretically, if you're going to prosecute them in a case in the future, you could use it against them.
That's right, Judge.
That's the idea. Okay. So that's a good thing to do, obviously. What are some of the other things when you talk about an assessment as to what services would be required? What would go into that assessment?
Typically, for protective orders, for example, there's an assessment that's called a lethality assessment. And that's part of what designates a protective order as either a high-risk protective order or not. In Bexar County, what we use at the FJC is the Jackie Campbell lethality factors test. And if you score above a certain number using that lethality test, that tells us that they're at a significant risk of intimate partner violence type situation, and we put a priority on the review of that case.
So you have different priority levels, I take it?
Yes, that's correct.
You have the highest priority then would be for a high lethality risk. And then what are some of the other factors that you look at? And what are some of the things that go into the assessment?
The central intake, essentially their role in the process is to figure out where the person is, what they need. You know, they may need food. Maybe their children don't have enough to eat. We have a food pantry that's on site that helps with that. Maybe they need to get involved in getting their kids enrolled in therapy. We have people who do child therapy there on site as well. Or maybe they themselves just need to talk to somebody, and we can set that up.
When I was a prosecutor working on protective orders, I have a situation that I'll never forget. And I know that protective orders have changed a lot in the last few years. Is that right?
Yes, sir. They changed significantly this September.
Mm-hmm. Well, what are some of the changes?
Well, the primary change that came about this last legislative session is that for family violence protective orders under Chapter 85 of the Family Code, the requirement that there be a showing of risk of future family violence was removed. Now, it only requires a single incidence of proven family violence to be eligible for a protective order.
That's a big one. I was working in the protective order area as a prosecutor. A lady comes in and she had never been assaulted before, but truly had felt fear for her life. And using the factors that we were able to use at that time, looking at the codes, she didn't qualify. She didn't qualify for us to represent her. She didn't really push it any further, but obviously she had some fear. I talked to my supervisor about it. He said, Ron, there's nothing we could do about it. And so as a result of that, we sent her away. Turned out she was killed. She was killed within a day or two of that particular meeting that I had with her. That's something that will impact me for the rest of my life. That's something I never forget when I walk into a courtroom. I think about that kind of situation. Do you ever go through things like that?
I have similar, feelings in my gut all the time. And I can tell you that generally speaking, I have a pretty high success rate of not having any recidivism as soon as my orders go into place. Mm-hmm. I have not had one of my victims die on me, thank God. But those are the things that haunt me at night. It's why I take home my work cell every night in case somebody needs me.
Obviously, we didn't just turn her away, right? We gave her advice. We told her, hey, stay out of the home. There's some shelters that you could go to. There's other things that you can do. Back then, we didn't have cell phones, so we weren't worried about that sort of thing. But, make yourself safe. Remove yourself from the situation. And, we always talked about it afterwards, like, is there anything different that we could have done under the law? That's a big change, that Chapter 85 change. What other kinds of changes have come about?
One of the other big changes that's kind of resolved an ongoing question of law as it pertains to the protective orders is they've now made it abundantly clear in Chapter 85 that if somebody is released from confinement, and while they've been in confinement or within a year of their release from confinement, the protective order has expired. Depending on how long they were in jail, it is automatically extended either 1 year or 2 years, depending on the length of the confinement. And upon release, it's supposed to be updated in TCIC and CIC.
So what they do then, before that person is released, they're actually handed and served that protective order to know this is in effect.
So when they sign under this new law, they're given a new notice that it will automatically be extended if they are in confinement or released from confinement, and it expires within the year. So an automatic extension in essence.
We're talking about protective orders. We're talking about how it works when somebody walks in the system. So let's say an individual goes in there, they're asking for help. They've applied. Your office recognizes that there is no conflict, can handle the case. The Jackie Campbell assessment is one where there is a significant risk of serious bodily injury or death. What happens then?
So what happens next is a prosecutor, like myself or my other 4 colleagues at the FJC, we review the application for legal and factual sufficiency. And if we believe that it merits a response and a filing, then we will file a protective order on their behalf. And depending on what factors are there and what the facts are, we may or may not be able to seek a temporary order of protection.
So you mentioned there are 5 prosecutors that work there?
Yes, sir.
And that's for the entire county?
That's for the entire county. Yes, sir.
Well, you go back and you file a protective order. What happens then?
So depending on whether or not a TPO is issued or a temporary order of protection, that determines whether or not there's already protection in place for that particular applicant or victim.
All right. So if somebody comes in, you've established that you're going to file a protective order on their behalf. You go directly to the judge without notice to anybody. In other words, it's called an ex parte protective order, right?
That's correct, Your Honor.
So you go to the judge and you say, respondent to this protective order is not here, but we want to do this protective order application on a temporary circumstance. So then after that, the individual who is a respondent will get served and there will be an actual court date, right?
Yes, that's correct, Judge.
So how effective is that temporary ex parte protective order?
It's effective as quickly as it gets served.
Mm-hmm.
So depending on how quickly you can find the guy, that's going to determine whether or not your victim has temporary protection. And sometimes they can be awfully hard to find.
What sorts of things does a temporary protective order allow you to ask for?
So a temporary protective order allows us to ask for the temporary imposition of all of the conditions that are statutorily mandated under a protective order application. So proximity restrictions with regard to their house, workplace, child schools or daycare type services. It also restricts their ability to communicate directly with the applicant or members of their family that are included on the protective order. And it prohibits, this is one that I had come up not too long ago, interfering with the custody or care of pets. Because unfortunately, more often than you would think, these types of cases involve some abuse to the pets.
With the protective order, can you remove somebody from their home?
You can. So the temporary protective order it's not the technical way to get them out of the home.
Mm-hmm.
The way you get them out of the home is with a kick-out order or an order of removal. We have authority under the statute, under Chapter 85, to seek a removal of somebody from the home if we can show that there has been violence within the last 30 days. A temporary order of protection may bar somebody who has previously lived at a location from returning. So, for example, if they're served while they're still in jail, they can't go back home. But we can't remove someone from a house without a kick-out order.
Temporary orders have really gotten stronger in the last few years.
Yes, Judge.
All right. So you get a temporary order, a temporary protective order. Let's say that person is inserved. How long is that temporary protective order good for until it expires?
So for the initial ex parte protective order that's issued initially by the judge, that order is in effect for no more than 20 days. 20 days is the maximum time allowed by the statute for that order to be in effect. However, that order can be extended if, for example, we agree to reset the case, which we do regularly, so that we can either facilitate their ability to have counsel represent them or so that we can conduct discovery.
So generally speaking, and this is an important point that you just bring up, civil cases don't mandate that an individual has a right to a lawyer. However, if there's a risk that person can go to jail for not complying with some order, then generally speaking, an attorney's appointed.
That's correct, Judge. So we have had that come up where someone has been near to holding themselves in contempt of our orders, and we've had the civil judges appoint them an attorney for those issues. But generally speaking, until that issue appears, they do not have a right to counsel the same way they would in your court.
If an individual is never found, let's say that they're eluding the authorities and that temporary protective order is never able to be served appropriately or effectively, what happens then?
Well, that depends on the nature of the case and what's appropriate. Unfortunately, for orders of temporary protection, there is a timing aspect and a temporal aspect to those where they will eventually lose their underlying support, which is we have to establish that there's a clear and present danger of the offense or the family violence that's underlying the application. So if we can't find him in time, eventually we're going to lose that temporary order. And then the question is, do we go forward without a temporary order, or do we non-suit until he appears again and then we can refile?
So somebody then gets served, they show up to court, it's their court hearing, the temporary ex parte order is still in effect. What happens at the court hearing?
So if they're not represented by counsel, we as the DA's office have a policy that we give them a laundry list of warnings, because this is a unique situation where a prosecutor, someone with the state of Texas, is talking to somebody who is potentially accused with crimes. Maybe they've even been magistrated on those crimes. And we're in a position where we're talking to them one-on-one and they don't have a right to counsel like they would in a criminal case. If you think this is fun, I can kind of do like a rehearsal of kind of how that conversation goes. Do you want to pretend to be Ron the respondent?
Absolutely. I'm the respondent.
Hello, sir. Before we do anything else, we're here today for a civil protective order case. I'm a prosecutor with the state of Texas. I don't represent you. I don't represent the applicant. I represent the state of Texas in this case. I can't give you any legal advice. We're here today for a civil protective order. This is not a criminal case. However, in the state of Texas, in order to seek a protective order, you have to allege that some type of criminal conduct has occurred. So the reason I bring that up is, generally speaking, before you speak to somebody who is a prosecutor with the state of Texas like myself, it's generally a good idea that you speak to an attorney first before you either talk to me about the facts of the case or share any evidence with me. That being said, because this is a civil case and not a criminal case, you are not afforded the same right to counsel the same way that you would be if this were a criminal case, where you would have one appointed to you if you couldn't afford one. They do not do that in civil court, but I can give you time if you want to have somebody represent you in this case. You just have to let me know before we do anything else. Do you want to speak to me one-on-one, or would you rather reset your case so you can have an opportunity to speak to an attorney first?
All right. So let's say respondent Ron says, I don't need a lawyer. Thank you for explaining all that to me. I kind of like you. You're like a nice person. Let's go ahead and go forward with this. What happens then?
So generally speaking, if they do want to go forward with it, I will make them an offer before we do anything else, or they offer to speak to me about the facts. Generally speaking, the incentives that we can offer in exchange for an agreement on a protective order, or that we can waive affirmative findings.
Family violence?
Yes, Judge. We can waive those findings. We can allow them to deny the allegations, so their agreement does not appear to be some sort of admission, and we'll include those denials within the orders. And then we can also negotiate on the length of the order itself.
Is there ever a circumstance where during that interview, a respondent makes admissions that then turns around and allows you to file some sort of other criminal charges against them?
I've heard of that happening with some of my other colleagues, but I have not had that happen personally to myself. I go out of my way to warn these people not to do it.
Right.
So generally speaking, they're keeping their conversations to a minimum or talking to their criminal defense attorneys about whether or not to tell me about that.
If you waive a finding of family violence, what does that affect? What does it mean when somebody walks away with a finding of family violence? And I had this conversation earlier with someone because they were talking about how the news talking about a deferred adjudication that was given on a family violent assault. And people were writing in saying, that means nobody will ever know once this case is terminated that this person ever had this finding or was found guilty of assault family violence. But the argument is no. The affirmative finding of family violence is something that never goes away. How does that affect somebody in their life to have that affirmative finding found against them?
There are lots of different effects that could negatively impact if you're the respondent and you have that finding against you. It could impact your ability to ever possess or own firearms, potentially. It could negatively affect your ability to ever purchase a firearm again, because it's going to show up on ATF and FBI checks. It has negative impacts on your presumptions when it comes to family law cases.
Like if you're fighting for child custody or something like that?
That's right, Judge. It has effects on spousal support as well. If you're a victim of domestic violence and there's an affirmative finding against the other party, there are potentials or the judge has discretion to increase the spousal maintenance or support.
I'm enjoying this conversation with Benton. Let's do a quick Q&A break. We'll be right back.
This is Q&A with Judge Ron Rangel. Submit your question today at beyondthegavelpodcast.com.
Welcome to the Q&A break. We have a question. In your last episode, you mentioned jurors that have broken the rules by talking about a case before deliberations. Do they get in trouble or flagged to not be a juror again, or are they thrown back in the jury pool? Oh, I like that question. So a few episodes back, I discussed a situation where we had a jury that violated some instructions that I gave them. Essentially, every time I swear in a jury to begin listening to a case, I instruct them that they're not allowed to get outside information and they're not allowed to talk to anybody, not even with each other, about the evidence in the case. In that particular circumstance, the jurors came in and talked about how there were some jurors that were in the jury room that were talking about who they believed, who they didn't believe, thinking that the defendant was going to be guilty, and they didn't trust the testimony of another individual. Frankly, they started talking about the case before I instructed them to begin their deliberation. That was a violation of the orders that I had given them. As a result, I had to call a mistrial. So what happens with those particular jurors that violated that particular conduct? Essentially, a judge could theoretically hold a juror in contempt if they violated a court order. Generally speaking, what I did in that particular case is I just called the mistrial, told them that they violated it, and then I released them from their service. They will go back in the jury pool at some point or another if they ever get their name drawn again. Thanks for asking that question. I enjoyed answering it for you. Please keep them coming. Let's head back to the show.
This is Q&A with Judge Ron Rangel. Submit your question today at beyondthegavelpodcast.com.
Welcome back. I'm here talking with Benton. Now, looking at it from the non-judicial standpoint, just an individual who's looking from the outside in, kind of a politically charged environment as it relates to protective orders. In other words, there's been a lot that has been made in the public sector, in the public conversation about family violence, especially during the pandemic. Is that something that you think affects the way that judges look at these cases? Does it cause judges, generally speaking, to sort of favor more granting these applications as a result of the potential ramifications if they don't?
I know that these cases are hard, and I know that, there's all kinds of things that are going on at the same time with these types of cases. And generally speaking, the types of cases that are eligible for protective orders are the types of cases that go on behind closed doors.
Right.
And they're already difficult enough before you start getting involved in ongoing divorce disputes and SAPSR matters that may be going on concurrently. And I think all of our civil court judges know that all those issues are coming up around the same time, and they're anticipating them as well. And we're just trying our best to get it right.
There's always that public debate about how far should the government go into somebody's household, into somebody's bedroom, into somebody's relationship. And I think back in the day, maybe when I was younger, it was a little harder for government officials to respond to issues like protective orders than it is today. So society has really changed as it relates to trying to figure out what are the underlying causes of crime, how to protect domestic violence victims, and how to strengthen the law in that area. A lot of people think a lot of things about protective orders. I'm sure a lot of people come in and tell you things and you're thinking, well, that's not quite how protective orders work. What are some common misconceptions that you come across in your job that people have about how protective orders operate?
The one that comes up the most is there's this conception that if you come apply for a protective order with the DA's office, then it's going into effect. Mm-hmm. And that is not how it works. It has to be reviewed, and we have to determine whether or not it's factually and legally sufficient before we're going to go make a filing with the court. And then just because we've made the filing with the court doesn't mean that there's a final order that's gone into place. So there is this misconception that once they've filled out the paperwork, it's done. And we try to remedy that as much as we can through the intake process, but it still exists. And the reason I know that is because I read about it in the reports related to our cases.
So they got to go through the court process.
That's correct. He's still got, he or she, whoever the respondent may be, still has rights of due process, and it's just one step.
When it comes to individuals that are coming into your office seeking protective orders, is there like a barrier or barriers that seems to be commonplace with those types of situations?
I think the majority of the barriers are economic. I would say that's probably the leading cause that people go back to the person that has abused them. Because, I mean, just if you think about it from a common sense perspective, they've had two incomes generally. It's now going to one. They have a lease agreement that's for two people. They now have the full responsibility of it if he's been kicked out. Maybe he has the car. And, this applicant who needs that car to go do daily chores or run errands now no longer has that available. And it's a serious burden on their life to have that much interrupted all at once. And you don't want them to go back to a position where they're trapped in that same cycle, but you understand it. And I think every prosecutor who handles domestic violence type cases knows those are the pressures that are going on, and we look out for it.
It's a big step, right? For somebody to come in and seek a protective order. They're actually oftentimes in their minds taking affirmative actions that are going to hurt them economically, maybe hurt them as it relates to shelter, children.
That's right.
With whatever help that they might need or feel that they might need in life.
It's a tough place to be in. I wish it was easier for victims, but there are a lot of pressures that are put on them, and I wish it was easier.
All right, so you mentioned earlier the code and the things within the code that allows you to apply for different types of protective orders. What are the different types of protective orders that people could seek?
They can be broken down into two categories, roughly. There are family violence protective orders that consist of either assaults or assaultive conduct or threats of bodily injury or death. So those are going to be your Chapter 85 type protective orders. There is a small subsection that rarely gets any use that deals with abuse of children that may include conduct that is not neatly fitting into either one of those previous categories, but that can also be defined as family violence under the code. Beyond the Chapter 85 family violence protective orders, there's also 7B protective orders. 7B is the Code of Criminal Procedure, and it does not require a family relationship between the parties. It can be against anybody regardless of what their relationship is. Those include cases like stalking. That's the majority of 7B applications.
And stalking, does that include like internet type stalking?
It can. Stalking is a very broad and inclusive statute and sometimes hard to read, but it can encompass a wide array of behaviors, as I'm sure you've seen in your court.
What type of evidence have you felt like you've needed? Let's say if you're going to go before a court and you want to show something related to stalking.
Well, in the era of digital discovery and evidence, the best and easiest to prove type stalking cases are the repeated threats that are either verbal, like on voicemail, or in text message form.
Right.
Those are the cases where we have the most success because they most neatly fall into the statutory description of what the elements require. But because stalking kind of encompasses both the harassment statute with a continuing pattern element that's added to it, there are a lot of other things that might meet those criteria that we just have to assess as they come.
There's something called emergency protective orders, right?
Yes, Judge.
And so that's related to somebody getting charged with a crime.
Right.
And then they go before a magistrate. And generally speaking, I think that is when those are applied for.
Yes, Judge. They're generally applied for by the arresting officer at the magistrate's office, and it's the magistrate's discretion whether or not those are issued.
What kind of offenses would qualify for something like that?
Domestic violence type offenses, as well as the typical 7B offenses like sexual assault, stalking, human trafficking, offenses of those nature.
Somebody's accused of a crime. They're out on bond after bail is set by a magistrate. What are advantages of having protective orders in place during those bond conditions?
I have this argument with my defense attorney counterparts all the time. We'll have applied for a protective order, and they'll say, there's already bond conditions in place. You don't need a protective order. And what I would tell those defense attorneys is, bond conditions are only in place so long as there's a criminal case that's pending. If that case is rejected for further investigation or whatever reason that case or charge gets dismissed, those protections go away, even if it's not something that has to do with the validity of the allegations of the case. Protective orders continue regardless of whether or not those are in place, unless there's a motion to vacate or the parties have agreed that it can be vacated.
And something that I just thought about as it relates to a bond condition. Bond conditions are such where if they're violated, the punishment is somebody goes back to jail because they violated their bond, but their case is still pending. So they still got to answer to the underlying offense that they're charged with.
That's true.
As it relates to a protective order, if somebody has a protective order against them and they violate that, now you're talking about a new and different criminal charge.
That's right, Judge. And depending on what those bond conditions are, they may also qualify as a new charge too, if it's in a family violence type offense. But one of the things that I do think protective orders do that may be better than a bond condition is bond conditions are typically issued right after the event has occurred. And it's in front of the magistrate. The magistrate is making a quick assessment of what is the appropriate way to protect the victim. And they aren't necessarily getting all the facts that we can get into at the time that we're negotiating a protective order. A protective order inherently, whenever we are seeking protection for somebody and we're speaking with a respondent, we can narrowly tailor the conditions of the protective order so that it can be something that works for both parties. For example, let's say the parties work in the same building and the respondent doesn't want to lose his job with the proximity restrictions that are associated with the protective order. He needs to go into the building. We can narrowly tailor that condition so that he can still go to work, he can keep his job, and our applicant can still be protected through all the other conditions by creating an exception that, it's surgical rather than a blunt instrument.
Right. You can figure out the circumstances in that particular case.
That's right.
Somebody violates a protective order. Initially, what's the charge the first time? The first time they get a protective order and they're charged with violation of it.
That's a Class A misdemeanor, Judge.
Which has a punishment range of up to a year in custody.
Yes, Your Honor.
And a $4,000 fine.
That's right.
They have one in the past that was adjudicated. Somebody was either found guilty or got some sort of deferred adjudication on it. The second one then becomes a felony.
That's right. A repeated violation of a protective order is, I believe, a third-degree felony.
Which is punishable by anywhere from 2 to 10 years in prison.
Yes, sir.
And up to a $10,000 fine. Let's say that person goes to prison. They're released from prison. Parole is over. Prison sentence is over. Whatever the situation is, they pick up another one. Now they're looking at a repeater.
That's right.
Which is from 2 to 20.
Yes, Judge.
In the penitentiary. And then let's say that then they go to prison. The sentence is satisfied. They pick up another one. Now they're habitual, which is minimum 25 years, up to 99 years or life. So there's some pretty heavy consequences for violating protective orders in Texas.
There certainly can be, and they escalate the more that they are violated.
And I'm going to ask you to put on your policy-making hat.
Okay.
Your public policy cap. What, in your opinion, could the state of Texas do to improve the law for protective orders?
I've got some ideas. My primary concern is that there are lots of areas of the law that and victims of crime that are not eligible for protective orders with the offenses that are articulated as they exist right now. The ones that I feel deserve protection that currently can't under these statutes unless they also qualify under other types of criminal offenses is sexual performance of a child, online solicitation of a minor, criminal solicitation of a minor. I believe those victims, they're not currently, but they should be entitled to the same protection that a protective order offers, and currently they're not. I wish they were.
That's a big one. Those are big.
But those are the types of things that occur in situations where they're often not a family member, where you can't use the family code to seek a protective order against that person because maybe they don't have a family relationship. And so 7B would be the only way that if we expanded 7B to include those offenses, that's the only way that we would be able to secure protection for those victims against their perpetrators.
Is there anything that exists in the law that allows the DA's offices to file something to keep an individual? I guess there's some sort of restraining order that would apply.
I wish there was, Judge, but as far as I know, there's not legislative authority that allows us to go into civil court and ask for those things. We can recommend that they seek it through a private counsel, but bond conditions are kind of where we're at on protecting those victims.
No contact orders.
That's right.
Benton, we've talked a lot about protective orders today. You've given us a lot of great information. Let's talk a little bit about you. When I introduced you, there was something about Netflix that you had been featured on.
Oh, yes, Judge. Back in my law school years, me and some friends got together and we made an album. And anyway, I was lucky enough to have one of those songs that's on that album featured on a Netflix show that maybe you've heard of. It's called The Ranch. With Ashton Kutcher and Sam Elliott.
That's impressive.
Thanks, Judge.
You're a songwriter.
I am.
Yes. What kind of music do you like to write?
Rock and roll, Americana, country music. It's a little bit of all of it all together.
When I was young, I used to think I wanted to be an actor. I was actually a drama major for a semester.
Oh, excellent. Theatrical or screen or?
Theatrical, yes.
Okay,
theater.
cool.
What is it that got you involved with making music?
My dad really, every trip we would take together, he had, Bob Seger and Keith Whitley and Tom Petty on the radio. Oh, wow. And we were both singing along. And so I loved it ever since I was a kid and picked up a guitar when I was 12 years old, learned how to play it, and haven't looked back since.
So when you came in here, you provided a DVD called
Bury the Hatchet.
Is that song available somewhere like on Spotify or anything like that?
Yes, Judge. It's available on all platforms. It's on Spotify, iTunes, YouTube, all of those.
There's a lot of songs on here.
Yes, Judge. Yeah. That's right.
You made, produced, wrote all these songs?
I wrote all those songs. My friend in Lubbock, John Taylor, produced those for me.
That's something you like to do?
I love performing and playing music. There's a lot about that aspect of my life that I miss a lot, performing, traveling around the state. There's some simplicity to that and some pureness that you don't have to grapple with all the major moral questions that we have to grapple with on a day-to-day. And I do miss that part of it.
It was good for your soul.
It was. Yes.
Yeah. Judge. So you traveled around the state and you performed?
Yes, Judge. That's right. I never made it too big. The best I ever did was I won a songwriter competition in Austin and got to open up for Jack Ingram at Billy Bob's in Fort Worth.
Well, do you still do that at all?
Occasionally I'll play country-style gospel hymns for my parents' church or something like that, but that's about the extent.
So if somebody wants to see you, they got to go to your parents' church.
Or request me, book me.
Any last words that you would have for anybody who's listening in on this podcast?
Just if you have any questions or concerns about protective orders, come visit us at the Family Justice Center. If you're a victim that's out there struggling with domestic violence or any sort of sexual offense and you want to come forward and get protection for those things, come visit us and we'll do our best we can to help you out.
I'm getting the sense that you really like your job.
I really do love being a prosecutor, Judge. I was a private attorney before I did this, and there's something that you just can't beat about being a prosecutor when you're motive and your job is to do the right thing. When you're a private attorney, you've got to do, to some extent, what your client is asking you to do within the constraints of the law. When you're a prosecutor, you do what's right. And that's liberating, and you can't get that anywhere else.
That's probably why you don't actually represent an individual person, right?
That's right.
You represent the state of Texas.
That's right.
Well, thank you so much for joining us today.
Thank you, Judge. Appreciate you having me.
I enjoyed our conversation.
Thank you.
You've reached the end of our episode. Thanks for listening. We'll be back in 2 weeks.
You've been listening to Beyond the Gavel with Judge Ron Rangel. Join us in the next 2 weeks where we are educating the public and expanding mindsets. Head to our website, beyondthegavelpodcast.com, or your favorite podcast platform to subscribe to the latest episodes and updates.